I'm the Robert Newton Reid Professor of Law at the University of Chicago Law School, and I'll be moderating this evening's discussion. And I'm delighted to welcome our speakers, Cristina Rodriguez and Adam Cox. They're the authors of the book, The President and Immigration Law, which was just published by Oxford University Press in the fall, and I have a copy to brandish right here. Cristina Rodriguez is the Leighton Homer Surbeck Professor of Law at Yale Law School. She is a nationally recognized scholar of administrative, constitutional, and immigration law. Her work has been published in numerous academic journals, including the Yale Law Journal, the Columbia Law Review, and Daedalus. In addition to her academic work, she also served as Deputy Assistant Attorney General for the Office of Legal Counsel in the US Department of Justice during the Obama administration. Adam Cox is the Robert A. Kindler Professor of Law at New York University School of Law. He's a leading expert on immigration law, voting rights, and constitutional law. His writing has appeared in the Yale Law Journal, the Stanford Law Review, the Journal of Law and Economics, and many others. And since this is a seminary co-op University of Chicago event, I also have to mention that Adam began his academic career at the University of Chicago Law School. So we're virtually welcoming him home tonight. So a few words about procedure. I'll start by asking Cristina and Adam a few questions, and they'll have a chance to respond. And so to our audience members, we invite your questions. I think what would probably make the most sense is if people want to write them in the chat section of their Zoom screen, and I'll then put them to our speakers. And hopefully that will work well. We can always modify on the fly as needed, because that's how it is with Zoom. Okay, so I guess the first question that I wanted to ask both of you, and maybe Cristina, I can ask you to go first, is could each of you talk a bit about what brought you to the project and what you think some of the most important or surprising takeaways have been for you, especially now that the book has been out and you've been talking about it and meeting with audiences?
So Adam and I started this project, I think in 2008, not the book itself, but the academic work that led to the book. We met very early in our careers at a conference in Las Vegas. And we both had the impression at the time, it was a conference of immigration law scholars, that everyone was focused on the role that courts played in interpreting immigration law, in shaping immigrants' rights, and the scope of judicial review and whether or not the courts could use things like the Constitution or other forms of restraint to limit state power in immigration was where all the action was. But we both thought that there was an underappreciated story, which was that Congress and the executive branch each played a role in the shape that immigration policy took, and that people didn't understand, and we certainly didn't understand, whether there were divergences, forms of collaboration, competition, and what shape immigration policy took outside of the courts. It was also at a time in legal academia when writing about the Constitution outside the courts had become an important part of public law scholarship and discussion. And so this was late in the George W. Bush administration. We decided to write a paper to look at the separation of powers dynamics in history. And so we did a lot of archival and other forms of investigation to see what we might find. And then lo and behold, 13 years later, it's a subject matter that's at the forefront of the news and of politics and presidential elections. And so we've not lacked material to motivate us to write and things to try to understand, including how we could see such wild swings in immigration policy over the course of what is actually a very short period of time, even though for us it has occupied the bulk of our academic careers. And I think in thinking about what has been the most surprising to me in doing the research is how consistent a pattern it is that whether it's the president or some executive official operating with statutory authority takes steps that seem like they're exploding the boundaries of the authorities that they have to create immigration policy that serves some kind of agenda. It could be an agency's agenda, it could be the president's agenda, and how even when Congress attempts to push back by going so far as even to amend the law, it doesn't seem to matter. And that might be an overstatement across the board, but there are a lot of instances of that. And it is a surprising dynamic, both because you would think that Congress's efforts to be very clear about its desire to limit presidential power would have more of an effect in the instances that we described than it has had, but also how, across political parties and administrations, the use of sometimes really insignificant seeming bureaucratic tools can actually really help set an agenda for an administration.
Great, thank you. Adam, what brought you to the project, and sort of surprises or takeaways that you'd like to talk about?
As Cristina said, it was, the project was a long time in fruition, and it was this kind of chance meeting in Las Vegas when we were young academics. And I was actually thinking about the president's role in immigration policy a little bit because of something that actually some folks who are on the screen may remember, is there was a tribute issue of the Chicago Law Review to Judge Dick Posner that I was writing a short piece about, which led me to begin thinking about this and sparked a conversation at this conference with Cristina. And, she talks about the passage of time, and I think one of the surprises, so let me say three things that I think have been surprising to me. One is just the way that the world kind of came to the project that we were working on. When we wrote the first paper, I remember presenting it and plenty of folks saying, well, this is sort of interesting, but not, not so important. And, the last two presidential administrations really changed the public's perception of the conversation. And so suddenly everybody wanted to talk about the thing that we were interested in, which was exciting. That was great. A second surprise, I think, which Cristina alluded to, is I was surprised by the extent to which, the roots of presidentialism in this arena dated back so far. And in our first project, we dated those roots to the kind of early to mid 20th century, but by the time we got around to working all of the research together into the book, we really came to see the way in which, from the very first days of the nation's existence, really the president was charting a path separate from Congress. And the sources of presidential authority changed over time. In the 19th century, it arose in part because the president stood at the center of foreign relations, and the treaty-making power was actually a big part of crafting early immigration law. And so the sources changed, but the role of the president really, was always important, and then only grew and was cemented over the course of these 20th century developments. That was the second thing I think that I found really surprising. The third thing, which I guess Cristina also alluded to, is the deeper we dug, the more we realized that often seemingly insignificant delegations of authority from Congress played, or overlooked delegations of authority from Congress played, a really big role in the exercise of presidential power. And the parole power, the power to allow immigrants who are excludable at the border to come into the country, that was used to craft American refugee policy in the middle third of the 20th century. Interstitial power, which grew into enormous force. And then more recently, although it actually reads as a big power, that the suspension power that President Trump used for the so-called Muslim ban and many other limitations on immigration, while it's drafted quite expansively, it had played a very small role really in the preceding years and had often been overlooked as a real source of authority by many lawyers and scholars.
Well, picking up on, I think, something both of you mentioned is the fact that this book, like most book projects, does grow out of pre-existing work and then spans a number of years. And in your case, that's particularly salient, as you mentioned, because it's a number of presidential administrations. So I like your phrase, Adam, that the world came to the project, because I'm guessing that while you were doing it, it might have also felt overwhelming at times. And it seems like one of the challenges of writing a book like this that's talking about legal issues and trying to reach a broader audience that's not just law professors and lawyers and judges, is trying to figure out how to parse the day-to-day and then the big picture stuff. So as you said, you started working on it during George W. Bush's office and then the Obama presidency, and then it came out at the very end of what turned out to be the very end of the Trump administration, and now we're in the Biden administration. So did you find it challenging? Let me come back to you, Adam. I mean, as you were sort of thinking about, especially your normative claims about what should happen, was it challenging to, given the rapid changes and frankly sort of about faces that you might have seen? How did you navigate that?
Honestly, it posed some real challenges because the landscape was always changing. We were always trying to absorb information about what was happening on the ground, and obviously the direction of presidential action, it's always evidence we're taking in as we think about how to evaluate it. So it's relevant and kept us busy. And that's part of the reason why the book took longer than we thought it was going to. But in another sense, as a scholar, it was a kind of an opportunity, because I'll confess that, when we presented the first early versions of these ideas, especially actually when we presented kind of the second paper, which was about DACA and written during the first or early in the second term of the Obama administration, a really common response we got from audiences of all types was, well, isn't this convenient? You guys are big fans of presidential power now that, President Obama is using it to protect people from deportation. And at the time, we would say, wait, we wrote the first paper in the latter Bush years, and that was our kind of our attempts to show, like, look, we have a kind of credible commitment across administrations about how we're thinking this through. The transition to the Trump administration tested that seriously, and although the shape of the book changed because we came to focus at the end of the book more on some of the pathologies of power that you do need to worry about in this presidential system, we felt like what we saw and witnessed during the Trump administration basically reinforced our core descriptive claims. Our claims about the role of the president just seemed all the more right the more we watched what President Trump was doing. And some of our more normative claims about the importance of supervision seemed to us like still correct, even though, of course, supervision can facilitate, cruel policies of the sort that we often saw from the Trump administration.
Christina, do you want to add anything? I'm guessing you do.
No, I will say we started writing the book after having written 2 substantial law review articles in 2015. And we thought we were writing a story in the midst of regime continuity. And there was not, I would say, a lot of normative in the book project. But then the 2016 election happened, and we both thought, okay, we have to take a step back and both make sure that we can capture what we think are going to be really dramatic changes, but also that we actually can credibly say the same things or similar kinds of things about executive control, and especially presidential control over the bureaucracy. And in ways that are arguably perverse, the last 4 years make the book a better book because it demonstrates the varied ways in which the system can be exploited depending on the agenda of the person in charge. And as Adam says, the last 4 years only reinforced our descriptive agenda, but then I think pushed us to include at the end chapters that were much better embody what our visions of immigration law and policy ought to be, and then how what we had been writing about in terms of the ways that the administration can control the levers of the bureaucracy fit into that, and how we reconcile views about institutional structure with views about the substance of the law. And I think that for people who do public law is an ongoing challenge, and we had to confront it in a way that was very visceral. And so that made it a more satisfying academic project, and hopefully one where we've actually been able, I think, to show both to ourselves, because we might have seen it before, but also to the people who are reading it, how the system is structured in a way that enables the kind of abuses that we saw the last 4 years, but where those same structures can actually be used not only to roll them back, but also to make the system better.
Yeah, and a question I had sort of on this, I think the more descriptive part, which is also interesting, right? Because I think a lot of people, as you say in the book quite candidly, And as you've just said in your comments, a lot of people assume that Congress sort of should be in charge, has been in charge, and to the extent the president's doing immigration policy, it's through some delegation, but it's really Congress that's in charge. And then, as you write, in nearly every clash, the president's detractors have invoked the same supposed constitutional wisdom: control over immigration belongs in the hands of Congress. So I'm wondering, I mean, why, this is getting more maybe substantive into some of the arguments of the book, but I think, as you say, to many people, that's a sort of surprise based on what they think they've seen or what they think they know from history, and also from the Constitution. So I think, we look at Article 1, Section 8, that Congress has the power to establish a uniform rule of naturalization, right? And as you say, a lot of people sort of point to this and say, well, that's all the Constitution says, but it's certainly in Congress's domain. So does your analysis, I mean, I think a lot of what you're talking about focuses more on what's happened in practice over a long period of time, as you said, Adam. What do you say to a reader, though, who sort of points to, say, that provision in the Constitution and says, well, maybe I don't care how it has happened, that's where it should be? Someone who's either an originalist or just says, well, the practice is one thing, but, to the extent the Constitution says anything, this is what it says. Is that a moment where we would say, oh, maybe, Congress should be more in charge here? I guess I will ask one of you. I'll do the law professor thing and cold call. So Cristina, can I come back to you on that one? So yeah, what do you say to the person who kind of disputes maybe both your premise and then how you make the argument?
So I think the way I would describe our constitutional argument is that we don't dispute that Congress has plenary authority here, and that Congress could, in fact, undo a lot of what executives have done. So in that sense, we're not claiming that there's inherent executive power, though in one of our first papers, we do trace a line of argument that goes back pretty far in the past, where the concept of inherent authority plays a role. But we don't dispute the scope of Congress's power here, but instead emphasize two things about the nature of that power. The first is that the system that we're describing today, that has its roots in the late 19th century, but really took shape through an important series of developments in the late 20th century, is a system of delegated powers created by acts of Congress in combination with presidents who supported them and executive officials who interpreted different iterations of the law that then shaped the way Congress might have amended them. So it's definitely, the system that we're describing, a product of a legislative process that includes a lot of executive involvement, but it's the nature of that delegation that has empowered the president and the executive branch more generally. And the core of our argument is in chapters 3 and 4 of the book, where we demonstrate how a set of legal and demographic developments create this enforcement system that enables the president and executive branch officials to essentially determine who stays and who remains, the core question in immigration law. And the reason is because there are more than 11 million people who are deportable under the law, but of course, neither the will nor the resources to remove them all. And then the choices get made through enforcement judgments and through a range of bureaucratic moves about how to manage the system, which is very complex underneath that number. There are lots of different complexities of status and relationship to the country and things of that sort. So the system of presidential powers, in a sense, one of Congress's own creation. And then we pivot to the question of how much of this is something we ought to undo. And that's where I think you cannot have an account that doesn't relate in some way to a vision of immigration law and immigration policy. A structural constitutional account is not going to tell you how this ought to be fixed unless you have strong views about the non-delegation doctrine, which I suppose we do, but not in the direction of reaffirming it or reviving it. And so in that part of the book where we talk about the state of affairs of presidential control through enforcement, we defend it as a second best state of affairs. affairs. It's second best because we'd rather have a world where there weren't 11 million people in constant danger of enforcement, where officials who use coercive and carceral techniques are driving decisions. And a lot of the back part of the book talks about why we think that is a state of affairs to lament. But given that that's the system that exists, we think that within it, it's important to have strong political control, not just presidential, but political control by political officials, because that's our best chance at introducing rationality and humanity into the system. And that to attempt to constitutionalize the way that line level officials or even intermediary officials are supervised by those who are in political positions would have unintended consequences and be a kind of intrusion into the operation of the system that wouldn't make for a better system and is certainly not required by our concept of separation of powers.
Great. Adam, do you want to add anything? Oh, I think you're muted.
I'm muted. Yeah, I think the only thing I'd add is just a point of emphasis, which is, I think Cristina is really conveying already, which is that, you know, we wrote a book that's really, it's not a book about ideal theory or, you know, of structural constitutional arrangements. I'm not so sure that either of us believes in such projects being possible. It's a project that's kind of, it's deliberately domain specific. There are general lessons, but in part because we think that, you know, you need to understand the context of a particular regulatory arena to understand the normative arguments about the allocation of power among the branches and within the bureaucracy. And our claim that flows from our understanding of the immigration system is in part a claim about second best arrangements. You know, I think we say candidly in the book, as Cristina notes, you know, would it were that we had a different world in which there, you know, it wasn't true that nearly half of all non-citizens in the United States were living here in violation of law, then another way of allocating power within the system might be much, much preferred to the allocation that we have. But in that world, you know, the choice is not whether to give the power to the president or Congress. The choice is really whether that power is going to get exercised by politically accountable senior officials and White House staff up to including the president, or instead it's going to be exercised much further down in the bureaucracy by, say, line level enforcement agents. And that's the choice we see. And there we think, you know, if that's the world we're in, we're pretty confident about our normative claim.
And speaking of some of the officials, I wanted to ask about the process of researching, because it seems like you've done it is clear you've done a huge amount of research across many, many different fields that I think we sometimes see people do some, but not nearly as many as you have. So you have interviews with officials, many of whom for obvious reasons remain anonymous. You also have more empirical work, you've done historical work, you're obviously reading cases, reading statutes. So could you talk a little bit about just the process? I mean, you're really trying to get your arms around a huge project here over a long period of time and make policy and normative recommendations. So what was doing those different kinds of research like? What were particular things especially challenging? Did it feel like to answer different questions, you know, you had to completely shift gears and look at different kinds of sources? Adam, can I start with you on that?
I mean, for me, I guess I can't speak for Cristina. I found it like amazing in some ways to be able to be working in so many different modalities within the same project. I felt like it provided us with, it allowed us to be really flexible about how we thought about trying to answer different kinds of questions that we cared about in the book. It obviously posed challenges because it did mean we had to like read a bunch of literatures. And I think that, you know, the hardest parts of the book probably, the hardest parts of the book were probably, you know, some of the historical parts of the book, but actually parts that are maybe barely observable to the readers, because there are times when, you know, when what we wanted to know was, the background political history of, say, the Gentleman's Agreement between Teddy Roosevelt and Japanese officials in the early part of the 20th century, like a lot of people have written about that. And so that was something that where we could read the archival materials ourselves to a certain extent, but also fill in and learn a lot from the large literature around those sorts of events. But there were other things that were important to us to know, like, well, how frequently was it the case that executive branch officials from about 1940 were using, discretionary forms of relief to help people who would otherwise be deported avoid deportation, because the statutes creating those powers existed from that point forward. And, answering a question like that, which might inform a sentence that we wrote in the book, ultimately sometimes took, dozens of hours, because just trying to figure out, like, did the INS even produce reports that would have had any of that information from that period? How can we find where those reports are, and then dig them up and hope that they'll contain the numbers that we need? And so, those were some of the invigorating portions of the research, because it was exciting when we find an answer, but it did require an enormous amount of legwork over time, which is maybe another reason why the book project took a little while.
Could be entirely reasonable. Christina, do you want to add anything?
Yeah, I'll add that it's clear that we could not have written this book when we first started this project. And it's not just because when we started, we had just started our careers as legal academics. It took a lot of time working in a lot of different modes, including my experience inside the government, to give the shape to this project. And in that sense, we're really lucky that the world came to the project, or that we found something interesting that became a mainstay of the headlines, because that gave us reason to continue. But as Adam says, the more we discovered its rootedness in the past, the more there was to research, and in many respects, lots of secondary literature to rely on. But then a lot of that literature didn't care about the legal questions that we cared about. Another example of the sort of thing Adam was describing was the Bracero guest worker program that began during World War II to address labor shortages in the Southwest was initially the product of a treaty signed between Roosevelt and Mexico. And it wasn't clear what legal authority Roosevelt was relying on. And so this might have been quixotic or idiosyncratic, but we spent a lot of time trying to figure that out. And the sociologists or historians who'd written about the program didn't care about that. And maybe we shouldn't have cared about that, but we did, because we were interested in trying to find instances of the assertion of this kind of foreign affairs-based or inherent authority to make immigration judgments. And this was, I think, motivated by the debates at the time about guest worker programs and whether George Bush had to go through Congress. And of course he had to go through Congress, but why was that so? And so that was part of the fun of the project, but part of why it was valuable to have it seem really current. And I will say another thing that we came to late in our research, but that was also really crucial in understanding the internal workings of the bureaucracy, were the interviews that we did. And we could have done many more than what we did, because people who had worked at middle or high levels inside the enforcement bureaucracy were very eager to talk about, and this is from the Bush, even back to the Clinton administration up through the Obama years, about what it was like to try to manage a bureaucracy in a politically fraught arena, while the bureaucracy itself was being transformed by Congress from being all within DOJ, Department of Justice, to being the Department of Homeland Security. And that, I think, also gave us a sense of realness in pursuing the project, and was a way to make us feel like both policy relevant, but in a way that actually showed people things that you wouldn't see unless you had a way to get in to the inside.
Yeah, and sort of a different tack, I think, but about the normative point and the sort of who's acting and at what level, this question. And then after you both have a chance to respond, we'll open it up for questions from the audience. So please submit them in the chat, everyone, if you'd like to. And this question is, we think about if the president is in charge, or sort of we're in this presidential centered model of immigration law that you propose, how is the president going to act? And a lot of it will happen through, as you both said, the sort of officials and line officials and people in the bureaucracy. But a lot of it will also happen through executive orders. And this is also something we're hearing a lot about right now. And people have short memories. Obviously, there's always the sense that everything is brand new, but especially I think with immigration, we've seen from presidents of both parties a lot of action by executive order. So President Obama's programs, DACA and DAPA, various others, President Trump's proclamation of the national emergency in 2019, the supposed national emergency on the southern border with where you start the book, and many others. And obviously President Biden has already signed a number of them. But then of course there's this criticism of executive orders. They're not durable, they don't stand up for as long, and that's part of why we have this back and forth. So Adam, let me start with you on this one, which is, how do you think about the executive order piece of this? It's a tool, and if you're going to a more presidentially centered model, I think you're making peace with that. Again, maybe it's second best. But what's gained, what's lost? Does it make some of these things more like political footballs, especially in an area like immigration?
That's a great question. It is. I mean, so at one level, the increase in action through executive orders, just publicizes to a greater extent practices that were already happening even prior to the last couple of administrations, right? So to the extent executive orders are directing, say, enforcement priorities, which was true for the Trump administration, you see is true already for the Biden administration with the announced moratorium on deportations. Decisions like those decisions were being made just deeper down in the bureaucracy, and so in a less transparent way. So it's not clear that what we're doing is substituting a less durable form of policy commitment for something that previously was more durable. It may be that, sort of since the rise of the massive shadow system that Cristina described, we've had a basic potential problem of a lack of durability to these policy commitments. But what's happened more and more in recent years is, in part because immigration has risen in political salience, those policy choices are being owned more frequently by presidents in public statements, whether they're cast explicitly as executive orders or not. So in a way, I think what we see is really just highlighting, the incentives that drive presidential action, in part because of the increasing salience of immigration policy. Now, underneath that, of course, so there's an issue that's maybe bigger than just the executive order issue, which is, to the extent a lot of this decision-making is happening through policy-making devices that lack durability, right? Whether they're announced by the president, or it actually was Jay Johnson, right, who announces the DAPA program, and Napolitano, who announces DACA. Whomever's announcing them, there is this character that they can be easily reversed. And that is one of the concerns that we identify kind of in the final part of the book, that you buy some responsiveness, obviously, but the lack of durability creates problems, especially when you're dealing in a regulatory arena where, a really important value is the security that immigrants obtain in their stay in the country, right? And so even when the president can make promises in, say, DACA to hand out permits, it still leaves folks feeling a sense of insecurity because they don't know if that policy commitment will obtain beyond this presidential administration. So to the extent we think we need to generate security, then we need to find other policymaking tools.
Thanks. Cristina, your thoughts?
Yeah, so I'll add that clearly relative to legislation, much of what we talk about in the book is not as durable. But I also think that the executive order is just a form. It's a legal form. And the real question is what's actually happening in that order. There are many, and some of these are are part of the most recent binding executive orders, many EOs that exercise express presidential authorities and do turn policy on a dime, like the 212F orders, the so-called Muslim ban or travel ban. Those undoing them cannot undo the damage that was done to people who were not permitted into the country, but that policy changes overnight. But one of the, I think, important things that we do in the book is to break down this concept of presidential power over immigration law into the parts of the executive branch that might be directed by the president, but that are doing a lot of the work. And when it comes to changes that have been made at that level, many of these executive orders, the ones we are seeing now, are just preludes to really hard work that's going to have to be done inside the bureaucracy if an administration wants to turn the regime around. So, for example, within the Department of Justice, through a variety of mechanisms, notice and comment rules, policy manuals, opinions by the Attorney General, the Trump administration remade asylum law, basically shut it down. It's not just their actions at the border that are characteristic of their approach to asylum. It's substantive changes to the law that make it much more difficult for people to make their claims and then to win them if they actually have the ability to make them. And those changes were all made through much more durable forms of executive action than the stroke of a pen on an executive order. And so it's more complicated than to say we're flipping back and forth. We're clearly flipping back and forth between two different substantive regimes, but there's a lot that has to be done to undo the prior regime. And that's, I think, an argument that some of the executive action that we're describing, even the enforcement directives, which are in the discretion of the secretary, can be sticky. And the way to undo that is through concerted political will. You cannot undo it if you don't pay attention to it. It's not going to happen by itself. And so, I think that each administration in an area that it cares about is aware of how it can make things last by reaching deep inside and changing things that might not be visible to people from the outside, or even to a high-level official who might care but isn't in the weeds. And so the durability story is more complicated, but of course, relative to something like a legalization program, DACA is nothing.
Yeah, excuse me. And that, I think both of your responses also go to something you spend a significant amount of time and fruitfully developing in the book, which is just acquainting probably many of your readers with the way enforcement works. I mean, just the many, many layers of bureaucracy, but in a sort of rigorous sense, bureaucrats doing things, making decisions, enforcing the laws, and really sort of beefing up what enforcement means. Although, as you note, at a certain point, that can become the pressure point that actually needs to be modified. So it's an enforcement issue that that things possibly exceed where the public, or much of the public, is comfortable with. So I think now is a good time to open the discussion to questions. Now, I think since we're a relatively small group, if people would like to raise their Zoom hand to ask a question, that would be great. Or you're welcome to put it in the chat. But since we don't have anything in the chat right now, I think it's also okay for people to actually ask questions by voice. So would anybody like to plunge in?
I have a question for Adam, if that's
within
bounds of other people.
Totally within bounds.
And I've given this a lot of thought, so he could ask it back to me too. But is there anything missing from the book, Adam? Or if you could write something differently now than we did, we put this mostly to rest a year ago, what would that be?
I guess the biggest thing that I think is missing, not because we didn't notice by the time we were putting everything to bed, but really because things were still developing and the project was just too close to complete, is I do think that when we started this work, back in 2008, we underestimated the extent to which, creative lawyering by executive branch officials would produce such significant authority on the part of the president on the front end of the immigration system. Our very first paper, right, we really emphasized this asymmetry, like lots of presidential power on the back end of the system. People are here, and then the president gets to pick and choose who gets kicked out of the country. And we said quite explicitly back in 2008 or 9, like not so much power on the front end of the system. And I think the last 4 years have kind of shown that, well, either we missed it back then, or the world has changed. Maybe the changing composition of the Supreme Court facilitated that a little bit, because the Supreme Court was very amenable to the broad arguments made by the Trump administration in several of these cases. Maybe changes in the world facilitated it as well. The growing role that refugee claims at the southern border play in our immigration system has created new opportunities for executive branch officials to shape what we think of as our admissions policies for asylees through changes to the asylum system. So I think that's one thing that it's obviously the book talks about things like the 212F power. There's a big part of chapter 2 that's about that. But I think were we to write it again, I'd spend more time thinking systematically about the exercise of that. We think of that as that ex-ante screening authority, that kind of front end power that the president, especially during the last 4 years, seems to have wielded. What do you think? What would be the one thing that you'd spend more time?
I agree with that characterization, and our thinking has moved a lot since 2008, which I take to be a good thing. If we were still saying the same thing, then this book wouldn't have been worth writing. But as you know, we focus a lot on control of the bureaucracy, but the bureaucracy we focus on is a specific one. It's the enforcement agents in the interior. And there are at least 2 other immigration bureaucracies that have different histories and different cultures that would have been interesting to do more to explore through the kinds of interviews that we conducted and through deeper research than what we did. And that's the Customs and Border Patrol and the Border Patrol. There is material about the Border Patrol, but we don't really understand the culture of the Border Patrol in the same way we do of immigration and customs enforcement. And I think it is a different entity, even more extreme than ICE, less professional. And it's related to what I think of as our present major challenge, and that's how to manage what's happening at the southern border. And that's going to bedevil the Biden administration, I'm sure. And then the other is better understanding the immigration courts. That's a different kind of bureaucracy. They're adjudicators. We want them to be independent. Exercising high-level control is much more fraught when you're talking about adjudicating cases of that sort than it is when you're seeking to control enforcement officials. And it's a bureaucracy the Trump administration tried to centralize, tried to control and enervate, essentially. And so that's something else I would have been interested in spending more time on. And there are others too. So I guess maybe there are other books to be written, but that's my current answer.
Yeah, it's always good to know there are other books to be written, right? It's always leave them wanting more, and always leave yourself thinking, there's a next chapter. So I'm excited to read those books and articles. Okay, so we have more questions. David Strauss, let me call on you first.
Thanks, and great to see you guys. Hi, Cristina. So this really follows on what Cristina just said. One agenda you could imagine for the Biden administration, or an administration that has its views about immigration, would be really to get hold of the immigration bureaucracy, and if possible to build it into a bulwark against the next nativist president. And the question is whether there's any hope for that, or whether they are irretrievably cops. And as Cristina said, there are multiple components, and maybe the Border Patrol is hopeless. But what about asylum officers at the border, or immigration courts, or State Department consular offices overseas, whom you would imagine maybe are sort of come at this completely differently from the way the enforcement people do. So is that a plausible agenda? Because you could see it not just as a matter of what you talk about so well, of making sure that they implement your agenda, but also the kind of thing that EPA does, where when someone comes in who's hostile to enforcing the environmental laws, the EPA is a problem for them. So this would be the other way around. If someone comes in who's hostile to immigrants, and finds it's a little bit difficult to round people up because the ICE agents aren't that interested in going and grabbing people out of families, and that consular offices are willing to give lots of visas to people and so on. Is that plausible, or based on what you've seen from the bureaucracy, is that just a pipe dream?
I think the easier answer is that it's a pipe dream for a reason that you gave, which is cops will be cops. I mean, they will. I think you can get a better quality enforcement officials, especially at Customs and Border Patrol, where the screening is lax and where the more prestigious law enforcement jobs are in the FBI or the DEA, and then you go on down the federal hierarchy. So that could probably be improved, but it's still going to be, those agencies will still be driven by an enforcement mission, which is why Adam and I, at the end of the book, advocate, because of our particular views on immigration policy, is shrinking of the enforcement domain so that they have less to do. I don't know if there are ways parallel to debates in the criminal justice system to repurpose them. It seems like then they just be officials of another kind. But as long as there are enforcement officials, I think some version of the cultures that we've identified could still exist. I mean, there's probably something to be said about the military background of a lot of people who go into these lines, and maybe that is a problem. And they're less. I've seen proposals for promoting things like community-based policing. I don't know what that exactly looks like for immigration officials and certainly for border officials, but there might be ways of changing the mentality where the enforcement is not just about arrest, detention, and removal, but might also be about assisting and finding ways of, forms of relief, or inculcating the concept of prioritization, which is something that we found both through our interviews and our work is difficult for enforcement officials to accept, which is why you needed, centralized programs like DACA to ensure that, in fact, they were not going to enforce the law in the way that the administration didn't want them to. But inculcating that concept of prioritization, I think, could be helpful. And I don't know exactly how you do that. And I'm not sure that the training programs that exist for agents of this sort are adequate. But I think that's the most you can aspire to in a world where you have enforcement bureaucracies. But maybe Adam has a more optimistic view of that.
No, I'm equally pessimistic.
Yeah, I'll just add one note on that. I mean, I think there are these moments too when you think about deterrence as the policy, right? The family separation and previous policies, but especially family separation, where then it's revealed that horrible conditions to deter were sort of part of the policy. So then I think that's like a completely different order of way of thinking about what the agenda might be, and pulling that back and then doing something like community policing just seems like such a total sea change. Yeah, okay. So next question from Lior Strahilevitz.
Hi, Adam. Hi, Cristina. It's great to see you both. Really fun project, and it's been neat to see some of these journal articles and know that there's a book that brings it all together and adds a lot more. So I'm interested, kind of like David was, in some of the recent events. And in particular, one thing that I can't remember seeing at the national level is the idea that, decisions about who to remove and who to admit have become politicized insofar as it becomes kind of a proxy war for what will the national polity look like. And so, one characterization of the Trump Stephen Miller regime is nativism, but in part nativism because of sort of traditional nativism, and also animus, but also a concern about, well, we don't want these people to become voters, because if too many Latin American immigrants become voters, then that's going to make it harder for Republicans to win elections 5, 10, 15 years from now. And so I guess I have a couple of questions that grow out of that diagnosis. And by the way, and Democrats may be in response thinking, in much the same terms, and that may inform the way that a lot of Democrats think about removal and asylum and DACA and pathways to citizenship. So I guess I wonder a couple of things. I've heard about big city machines trying to bring newly immigrated Americans into the fold and turn them into machine voters. But I wonder whether, prior to the most recent decade, whether that idea of immigration policy as a way to affect the nature of the polity and especially the partisan skew of the polity. I wonder if that's something we've seen before during earlier eras of immigration policy. And second, I guess, if it is a new development or maybe an old development that's it's coming around for the second or third time, does that dynamic affect the allocation of decision-making responsibilities, or how we ought to think about sort of who makes the decisions about who's removed and who's admitted, insofar as that's also a decision about what the polity looks like today and tomorrow?
Right. So on the first point, the kind of historical connections to current practices, the practice of using immigration policy to shape the structure of the national policy is as old as immigration policy itself. So even actually it predates it. So prior to the nation's first experiment with immigration policy in the Alien Friends Act, which authorized the president to deport dangerous non-citizens, Congress had already, in the run-up to that episode and in fear of French sympathizers, basically, had already extended the naturalization period to make it harder and harder for new immigrants to become citizens. And the worry was that they would become voters who would be like voting their French sympathies instead of voting to support the Republic. We see that again and again in the 1850s, when the fears about Irish Catholic immigrants, the Know Nothing Party rises to power. It takes control of a bunch of state legislatures, and in some places, like in Massachusetts, passes laws that say even once a non-citizen naturalizes, so becomes a citizen of the United States, they must wait 15 years before they can vote in Massachusetts elections. And obviously, we see it in lots more recent episodes. So this has been with us for a really long time. One thing, so how does it make us think about the allocation of power? And about who should make the decisions. I think a kind of old separation of powers story might lead us to say, well, that means if these are really fundamental decisions about the structure of the policy, they should be made by our most representative institutions. And so we should think we want Congress setting these policies and not executive branch officials. That might lead us to think there should be some kind of like an extra powerful non-delegation doctrine or something for these matters in immigration policy. That's unlikely to happen as a matter of constitutional law. But I guess I want to note one aspect of the kind of political economy that connects to this allocation question, which is if what causes logjams in Congress or massive policy shifts across administrations is in part this close connection between the acquisition of status for immigrants and their ultimate acquisition of voting rights, you can imagine political bargains. I'm not sure we would think they're political bargains that are healthy or that we want, but you can imagine, if what many immigrants most want is security, then there might be bargains to be struck, because part of the reason why immigrants lack security prior to naturalization is because today, even green card holders, and definitely holders of all temporary statuses, are subject to these broad grounds of deportability that contain no statutes of limitations. And so even if you've lived in the country for a really long time, you're still subject to them. So you could imagine reshaping immigration law to lower the stakes in a way by, say, imposing statutes of limitation on all of the grounds of deportability. Then legislation or other forms of executive action that gave unauthorized immigrants or other immigrants like status as green card holders, even if that status was short of citizenship, would give them security of residence. They could no longer be deported, right? Even if they lacked full membership in the polity and access to federal voting rights, for example. So, we see these kinds of trades proposed in part because what you'll see in legalization legislation are fights about the duration of the temporary status before immigrants become green card holders. That's a proxy for the time until naturalization. So that's what the fight is really over. It's just over what you're talking about. But I'm suggesting there are ways to kind of peel that apart a little bit if you rethought about the way that time limits work for deportations.
Just say one quick thing about the distribution of power. So one version, a different way of telling the story of what we call de facto delegation, the creation of this shadow system where the executive's controlling who stays and who goes, is that it was all it has been a deliberate strategy to create an exploitable labor force, and that is what our immigration system is. And you could rewrite big parts of this book through that critical lens, and if that and it is in fact one explanation we give as a potential explanation for why Congress has ceded so much authority to the executive by allowing this enforcement system to continue, because it's complicit in that. It wants that kind of labor force that's operating under the threat of deportation. And if that's the account, and that's related to your history of racial formation in this country and the history of Mexican migration in particular, then I don't think the distribution of power question really gets you anywhere, because it's the whole system that's working to produce this. And in that sense, some of the questions that we are concerned about as constitutional lawyers fall away. And it's really more about the political economy of immigration. And that would have been an entirely different book, though it's still present in our book. And it's conceivable that it's informing what Adam and I think about executive power versus legislative power, which is there's no reason necessarily to prefer one over the other. They work in different ways, and you don't want to hamstring yourself in pursuit of a system that's fair.
We're almost out of time, but I know we have one more question. So Bridget Fahey, do you want to just ask your question, and we'll see if we can get to it, please.
I'll ask it really quickly. Good to see you guys. I had a question sort of related to David's about the kind of moment of transition that we're in now, and in particular about how kind of presidential control over the immigration system just looks different for Democratic presidents and Republican presidents, because for Republicans, the infrastructure and the culture of these agencies is like a power multiplier, and for Democrats, it's like a power constrainer. And so, as constitutional theorists, like we talk about the president and Congress and are sort of often neutral to who's controlling those bodies. But, I just wonder about what it means, to talk about the president as being kind of preferable because of his, maybe someday her, political accountability when Democratic presidents are kind of more constrained in how politically accountable they can be because of the infrastructure. And then on the other side of that, thinking about Congress and the ways that, Congress can delegate policy-making power, and that can be sort of empowering to any kind of president, regardless of party. But that with respect to immigration infrastructure, Congress kind of just dead weights Democratic presidents. So I was just curious to hear your thoughts on this as we sort of move into a bright new world, maybe, depending on your answer to the question.
Yeah, I think that our initial view going into this is that there is an asymmetry in the way that a president can take advantage of the bureaucracy or its relationship to the bureaucracy, depending on the party. And the early story of the Trump administration was of unleashing the enforcement bureaucracy. But I think what you actually see, if you look at the sweep of the last 4 years and everything that's happened below, the salient level into the weeds, is that Republicans have to work just as hard to manipulate is a strong word, but to shape the bureaucracy and the policies that govern it to achieve their agenda. Not least because, there's this whole system of immigration courts that might be more in tension with the Republican line, at least as long as Congress allows forms of relief to continue to be offered, but also because there is inertia in the system. And if you have a system that's about giving out visas, there's going to keep giving out visas. And you really have to work hard to prevent them from doing that if your goal is to stop people from entering the system, which was a goal of the last regime. And so it really depends at the level which you're looking at this. Sometimes it seems like it's all politics, but in fact, it's not all politics. All the way down, the institutions get in the way. And we try to tell that story without making it a muddle of, everything matters. And we hope that we succeed.
Adam, do you have any quick final thoughts? Okay. We are out of time and there are more questions, but that's the sign of a good event, I say, and a wonderful book. So let's thank our speaker, authors, Adam and Cristina.
Thanks everyone for being here.
Thank you. And thanks everyone for attending.
Thanks,
Take
everyone.
care.
Take care.